Hi everyone, welcome to part 2 of the week 4 lecture videos. In this video, we're going to be looking at the concept of justiciability, which broadly is the idea about whether an issue of law is appropriate or fit for judicial determination or evaluation. Not every administrative decision is going to be appropriate for a court to review. And underpinning that are two key principles. First is the separation of powers, which we've covered a little bit in this course already. And the broad idea here is that while the judiciary has a lot of power to hold the executive and also the legislature to account, it's important to keep those powers separate and to make sure that no one branch of government has too much power over the others. And so in terms of the separation of powers and the relationship between the judiciary and the executive, it means that not every decision of the executive will be reviewable by the judiciary. So some things which are really core to the executive's function won't be appropriate for a court to review. So for example, in the Australian context, the Governor-General has the power to declare war. The Governor-General does that under instruction from the government of the day, but it's a core function within the executive, the power to declare war or not. Because that's so central, the protection of the nation, generally the courts would feel that that's not a decision that they are best placed to review. That's something that the executive, with all the information before it, would be best placed to decide. And so generally the courts aren't going to be too interested in reviewing that decision or not. Other decisions which are not quite as central to the executive's function and the heart of what the executive should be doing for Australia, the court will be more open to reviewing because it has that sort of oversight role within the separation of powers. The other sort of limitation on the judiciary's ability to review a decision, or the appropriateness of a court to review a decision, are some concepts about judicial power. And in particular, under this common law system that we've got in Australia, we generally think of courts having power to determine rights, individual rights or rights of parties in a clearly defined dispute. And so what that means for us is that the court won't be interested in an issue if it doesn't affect someone's rights, and they won't be interested in making a broad determination. There has to be an actual conflict between one or more parties and the government or the decision maker. And so that's a really critical distinction that's going to help guide us through these ideas of justiciability. When we think about justiciability in the Administrative Decisions Judicial Review Act, sections 5 to 7 provide for judicial review and empower citizens to apply for judicial review. So they're broadly tagged at the same thing. Section 5 looks at reviewing a decision. Section 6 looks at reviewing conduct by a decision maker, and 7 gives you the ability to review a failure to make a decision. In this course, I'll usually refer to decisions, which effectively is referring to Section 5, but the principles also apply equally well to Section 6 and Section 7. It's just easier throughout the unit to talk about decisions, but conduct and a failure to make a decision are equally reviewable under sections 6 and 7. So that's something to keep in mind. Broadly, in order to be reviewable, there have to be 4 elements have to be met. First, we have to have a decision, or in the cases of section 6 and section 7, conduct or a failure to make a decision. Then that decision has to be of an administrative character, made under an enactment, and not fall within a class of excluded decisions. So we're going to unpack each of those points in a little more detail. So let's start by looking at a decision and what that means. And we've got some guidance from the court in Australian Broadcasting Tribunal and Bond about what types of decisions they're referring to. And the first important point is that a decision means a decision that's final, operative, or determinative. So there has to be some degree of finality to the decision that's been made. Apart from options for review, which we're talking about in this unit, there's no point reviewing a decision if it's not the final decision. If it's still just a tentative conclusion, if it's just a working decision while they find out more information or something like that, generally that won't be reviewable. The class of decision that we're interested in is the final outcome. The second element is that the decision has to be substantive. There has to be some actual effect on someone's rights, their material interests. It has to have some impact on someone. What the court isn't interested in is procedural decisions. So, for example, a decision maker's decision to go about making a decision in a particular way, or something really procedural like deciding to hold its hearing on a Tuesday rather than a Wednesday, something like that. It has to affect the actual rights of someone. Now, I realize in saying that starts to blur a little bit about the distinction that we've talked about in terms of merits review and judicial review, in that judicial review is interested in procedural elements of the decision. So let me just clarify what that distinction is. The grounds of review that we'll be talking about in coming weeks are focused on procedure, but what we're interested in is the outcome of that procedure on someone's rights. If there's no actual impact on someone for having a hearing on a Tuesday versus a Wednesday, then that's not reviewable. If holding a decision on a Tuesday versus on a Wednesday did impact, say, the applicant's ability to present evidence, then, as we'll see in later weeks, that might itself be a ground of review because it means that the applicant hasn't had a fair hearing, something like that. So that's a procedural element, but it has a substantive impact on a person's rights. Where there's no impact on rights, it's purely procedural, almost a sort of a formality, then that's not a kind of decision that the court will be interested in reviewing. It won't be justiciable. There's a little bit of a grey area when we think about intermediate decisions. As I've said, the court is interested in the final decision, but what if a decision that was made along the way has an impact on that final decision? Perhaps then it will be reviewable. And that was sort of what happened in Australian Broadcasting Tribunal and Bond. The Broadcasting Tribunal was responsible for issuing or revoking broadcasting licenses to companies or corporations, media corporations and things like that. Mr. Bond owned a group of broadcasting corporations, and the tribunal, in assessing whether the corporations that Mr. Bond owned should have a broadcasting license, they determined that Mr. Bond himself was not of good and proper character. He wasn't fit to run those companies, and therefore shouldn't be able to have a broadcasting license. What Bond wanted to argue was that decision along the way, that sort of first step, that he was of poor character, that he could review that. And so there was this question of, well, can you review a decision? It wasn't the final decision, but it had a really massive bearing on the final outcome. If the Broadcasting Tribunal had found that Mr. Bond was of good character, then it probably would have granted his companies that license. The court in that case found that decision about Mr. Bond was not reviewable. And so they made some interesting comments about intermediate decisions. They said that under some circumstances, an intermediate decision would be reviewable, but only if the legislation requires that intermediate decision to have been made. Then it will be reviewable. If it was just a step along the way that the decision maker went to, which is what happened with the Australian Broadcasting Tribunal, then it won't be reviewable. But if the legislation specifically says first you have to decide A, then you have to decide B, you could ask for a review of A before you got the decision of B. The second point is that the decision has to be of an administrative character. So what does that mean? Well, rather helpfully in Burns and Australian National University, the court said that an administrative decision is a decision that's not legislative and not judicial. So helpful, but also not really helpful. Luckily, we've got a bit more clarity from Visa and RBA, where the court listed some factors that will help us identify whether a decision is administrative versus judicial or legislative. And so I'll quickly run through these dot points. They're relatively self-explanatory, but I'll quickly run through them. So first, if a particular decision determines rules of general application, it's probably going to be legislative. But if it applies general rules to particular cases, it's more likely to be administrative. So if it sets out the general rules, you can get a driver's license if you are 18 and you pass your test and you've, meet these requirements. You don't have any problems with your vision or something like that. Those are general rules that apply to everyone, probably legislative. If it's you as an individual, have you passed your test? Have you met all the other requirements? Are you over 18? Yes, you can have a license, more likely to be administrative. If Parliament has a control over the decision, it's more likely to be legislative because Parliament is the legislature. Public notification of making the regulation is probably also going to be more likely to be of legislative character. We tend to see administrative decisions being not publicised as broadly because they don't affect everyone, so it doesn't need to be broadcast. It would only be if the media picked it up or something like that, but the decision maker themselves aren't usually broadcasting it. If there's been public consultation and the extent of that public consultation, it's going to lean more to the side of being a legislative rather than an administrative decision. This one's a little bit more of a grey area. Some administrative decisions do engage with quite widespread public consultation, but as a general rule, we can think of consultation as being indicating a legislative decision. So be a little bit careful with that one, but if there's broad consultation, maybe legislative. If there's broad policy considerations imposed on the decision, it's also going to be more likely to be legislative. And that comes back to sort of the first point. If we're determining the rules that affect everyone, then broader concerns about policy are probably going to inform that outcome. If we're applying a set of rules to an individual case, then usually really broad scale policy considerations aren't going to be brought to bear as much on that individual case. The variability of regulations will also point towards legislative character. The power of the executive to vary or control the decision is more likely to lean in favour of an administrative decision. The provision for merits review also would indicate to us that this is an administrative decision, and also the binding effect of that decision is probably going to point towards an administrative decision having been made rather than it being a broad parliamentary decision. So that's just a quick list. It's not a guarantee, but usually if you can tick off, it applies specifically to an individual case, Parliament doesn't have any say, there's no broad policy considerations being imposed, and there's merits review, you probably a pretty safe bet that it's going to be an administrative decision. But it is something that is decided on a case-by-case basis. Third, the decision has to be made under an enactment. And so what that means is that the decision itself has to take its legal force from statute. Now, that idea was teased out quite interestingly in Griffith University and Tang. And in that case, Tang was a PhD candidate at Griffith University, but he was kicked out of the program for academic misconduct. That was a decision made by the university's sort of education committee, who themselves were set up under the sort of Griffith University Act. So the Griffith University Act was a statute that gave the executive, the education committee, power to make decisions about PhD enrollments and things like that. And so the committee in Tang's case said, you've engaged in academic misconduct, you're out. Tang argued that that was an administrative decision made under the enactment that was the Griffith University Act. But the court took a different approach. They said that the education committee itself had legal force from the statute, but the relationship between the education committee and Tang was actually contractual. When he signed up to the PhD program, that's what governed their relationship, not the Griffith University Act. And so even though there was sort of a sort of stepped process between the Act and Tang, really the relationship was governed by contract, not by an administrative decision. So in that instance, the decision was not an administrative decision. It was not made under an enactment because the education committee was empowered to kick Tang out for academic misconduct because it was in the contract between the two of them. Nowhere in the Griffith University Act did it say the education committee can kick people out for academic misconduct. That wasn't in the enactment at all, and therefore the specific decision couldn't have been made under that enactment. So in order to decide in, say, a hypothetical scenario, whether a decision has been made under an enactment, you need to look at the Act and look at, can you point to, say, a particular provision in the Act that says a decision maker has the power to make this decision or make this order, do this thing, whatever it is. You actually need to be able to point to the Act itself to find sort of that power or that authorization, whatever it is. And if it's not in there, then it's probably not going to have been a decision made under that enactment. And lastly, we need to make sure that the decision hasn't been excluded. Your study guide lists a whole bunch of exclusions. Just a couple of examples. Decisions made by the Governor-General are not reviewable. They're specifically excluded. And that's because the Governor-General is the sort of representative of our sovereign monarch, the Queen. And so those decisions are not reviewable. Schedule 1 also lists a whole bunch of decisions that won't be reviewable. Decisions made under security legislation are excluded, although the court has said that they are pretty keen to still follow the rule of law, and just because it's a decision made by ADJR or something doesn't mean it will automatically be completely unreviewable. If it's specifically targeted at security interests, then they won't take a look at that. Some decisions by the Attorney General won't be reviewable. In particular, those are decisions around whether they'll prosecute or engage with a legal matter or not. But you do need to have a quick look through the detail of that. Privative clauses under the Migration Act are excluded. So a privative clause is where an act like the Migration Act specifically says this is not a decision that the court is allowed to review. So a decision made under this act is unreviewable. Now, there are some very limited exceptions under common law. So you could still review, but you wouldn't be able to use the Administrative Decisions Judicial Review Act to review that decision because it's been excluded. Similarly, decisions under the Extradition Act are not reviewable, and that's because that's a really complex system of relationships with other countries, and so because that's a really sort of delicate international framework, we generally don't want people being able to interfere with the sort of diplomatic arm of that, those sorts of decisions, and so decisions under the Extradition Act usually won't be reviewable. They'll be excluded under the schedule. So that's justiciability in a nutshell. So just to reiterate, we're trying to check off 4 elements: a decision, so final and substantive decision, of administrative character, so usually affecting a particular individual person being made by the executive, made under an enactment, so specifically empowered by a statute, and that's not excluded, so not in Schedule 1 of the Administrative Decisions Judicial Review Act. So if you can meet those 4 elements, and for the most part you will be able to, then the decision will be justiciable. It will be allowed to be reviewed by the courts. We'll come back in the 3rd video to talk about standing, which is the final element in determining whether judicial review is going to be available. So we'll see you then.